Overtime is the amount of time someone works beyond normal working hours. Normal hours may be determined in several ways: by custom, by practices of a given trade or profession, by legislation, by agreement between employers and workers or their representatives. Most nations have overtime labor laws designed to dissuade or prevent employers from forcing their employees to work excessively long hours. These laws may take into account other considerations than the humanitarian, such as preserving the health of workers so that they may continue to be productive, or increasing the overall level of employment in the economy. One common approach to regulating overtime is to require employers to pay workers at a higher hourly rate for overtime work. Companies may choose to pay workers higher overtime pay even if not obliged to do so by law, particularly if they believe that they face a backward-bending supply curve of labor. Overtime pay rates can cause workers to work longer hours than they would at a flat hourly rate. Overtime laws, attitudes toward overtime and hours of work vary greatly from country to country and between different economic sectors. Time off in lieu. Time off in lieu, compensatory time, or comp time refers to a type of work schedule arrangement that allows workers to take time off instead of, or in addition to, receiving overtime pay. A worker may receive overtime pay plus equal time off for each hour worked on certain agreed days, such as bank holidays. In the United States, such arrangements are currently legal in the public sector but not in the private sector. For example, non-exempt workers must receive at least 1.5 times their normal hourly wage for every hour worked beyond 40 hours in a work week. For example, workers who clock 48 hours in 1 week would receive the pay equivalent to 52 hours of work. With comp time, the worker could forego the 12 hours of overtime pay and instead take 8 paid hours off at some future date. In some other jurisdictions, such as Canada, employers might be required to pay the overtime at the higher rate, but also be allowed to require time off in lieu at the normal rate. Thus, an employee might work 48 hours in 1 week, and 32 hours the next week, and be paid an extra amount equivalent to 4 hours work. In Australia, such arrangements both in the private and public sector are common. In some cases, particularly when employees are represented by a labor union, overtime may be paid at a higher rate than 1.5 times the hourly pay. In some factories, for example, if workers are required to work on a Sunday, they may be paid twice their regular rate, i.e., double time. Overtime laws by jurisdiction. European Union directives issued by the European Union must be incorporated into law by member states. Directives 93/104 EC, 2034 EC, which limited working hours, were consolidated into 2003/88 EC. Employers and employees can agree to opt out, under certain circumstances. The directives require maximum average working week of 48 hours over a 17-week reference period, minimum daily rest period of 11 consecutive hours in every 24, breaks when the working day exceeds 6 hours, minimum weekly rest period of 24 hours plus the 11 hours daily rest period in every 7-day period, minimum of 4 weeks paid annual leave, night work restricted to an average of 8 hours in any 24-hour period. The directives apply to all sectors of activity, both public and private. Doctors in training used to work a maximum week of 58 hours until 2009. From the 1st of August 2009, their maximum working week fell to 48 hours. Exemptions. Member states of the EC may exempt managing executives or other persons with autonomous decision-making power, family workers, and workers officiating at religious ceremonies. These are workers whose working time is not measured or predetermined or can be determined by the workers. Other categories can be exempted from the directive's key provisions provided compensatory rest or appropriate protection is granted. These include employees who work a long way from home, or whose activities require a permanent presence or continuity of service or production, or who work in sectors which have peaks of activity. Examples include offshore workers, security guards, journalists, emergency workers, agricultural workers, tour guides, etc. In Japan, the Labor Standards Act of 1947 provides for an 8-hour workday and 40-hour work week with at least one day off per week. The Act requires a premium of at least 25% over the ordinary hourly wage for any overtime work, 35% for any work on prescribed off days, and an additional 25% for any work between 10 p.m. and 5 a.m. Employers must enter into an overtime agreement with a labor representative prior to any overtime work by employees, and this agreement must stipulate to the maximum number of overtime hours that an employee may work, which may be no more than 15 hours per week, 45 hours per month and 360 hours per year. United States federal overtime law. In the United States, the Fair Labor Standards Act of 1938 applies to employees in industries engaged in or producing goods for interstate commerce. The FLSA establishes a standard work week of 40 hours for certain kinds of workers, and mandates payment for overtime hours to those workers of 1½ times the worker's normal rate of pay for any time worked above 40 hours. The law creates two broad categories of employees: those who are exempt from the regulation and those who are non-exempt. Under the law, employers are not required to pay exempt employees overtime but must do so for non-exempt employees. Independent contractors are not considered employees and therefore are not protected by the FLSA. Several factors determine whether a worker is an employee, who might be entitled to overtime compensation, or an independent contractor, who would not be so entitled. The employment agreement stating that a party is an independent contractor does not make it necessarily so. The nature of a job determines whether an employee is entitled to overtime pay, not employment status or the field of work. Classes of workers who are exempt from the regulation include certain types of administrative, professional, and executive employees. To qualify as an administrative, professional, or executive employee and therefore not be entitled to overtime, 3 tests must be passed based on salary basis, duties, and salary level. The tests vary between administrative, professional, and executive employees based on their different duties and salary levels. There are many other classes of workers who may be exempt, including outside salespeople, certain agricultural employees, certain live-in employees, and certain transportation employees. Employees can neither waive their FLSA protections nor abridge them by contract. An employer may not retaliate against an employee for filing a complaint or instituting a proceeding based on the FLSA. An employer that engages in any form of verifiable retaliation would be liable under the Fair Labor Standards Act Section 216 for equitable relief, including reinstatement, promotion, payment of lost wages, and payment of liquidated damages. Acts of retaliation include terminating employment, disrupting the workplace, threats, acts of physical violence, and constructive discharge. Out of approximately 120 million American workers, nearly 50 million are exempt from overtime laws. In 2004, the United States was 7th out of 24 OECD countries in terms of annual working hours per worker. On August 23, 2004, President George W. Bush and the Department of Labor proposed changes to regulations governing implementation of the law. According to one study, the changes would have had significant impact on the number of workers covered by overtime laws and have exempted several million additional workers. The Bush administration maintained that the practical impact on working Americans would be minimal and that the changes would help clarify an outdated regulation. In particular, the new rules would have allowed more companies to offer flex time to their workers in lieu of overtime. California overtime law. The state of California's overtime laws involve overlapping statutes, regulations, and precedents that govern the compensation of employees in California, while the governing federal law is the Fair Labor Standards Act. California overtime law is codified in provisions of the California Labor Code and in wage orders of the Industrial Welfare Commission because there are two sources of applicable law. A California employer must comply with both. In California, based on California Labor Code 1171, only an employment relationship is required for overtime rules to apply. Under the California Industrial Welfare Commission wage orders, an employer is any person who directly or indirectly, or through an agent or any other person, employs or exercises control over wages, hours, or working conditions of any person. Under the California Labor Code, an employee is any person, including aliens and minors, rendering actual service in any business for an employer, whether gratuitously or for wages or pay, whether the wages or pay are measured by the standard of time, piece, task, commission, or other method of calculation, and whether the service is rendered on a commission, concessionaire, or other basis. Independent contractors are not employees covered by overtime laws. So it is important to determine if a worker is an independent contractor or an employee. California overtime laws differ from federal overtime laws in many respects. Foremost, pursuant to California Labor Code Section 510, non-exempt employees must be compensated at 1.5 times the regular rate of pay for all hours worked in excess of 8 hours in a workday, 40 hours in a work week, and the first 8 hours of a 7th consecutive workday. Employees in California are entitled to double time for working more than 12-hour workdays or more than 8 hours on the 7th consecutive workday of a single work week. Under federal law, there are only 40-hour weekly overtime limits. This 8-hour overtime limit in California frequently gives rise to wage and hour litigation for violations of state, but not federal, labor laws. For example, comp time schemes, where employers tell employees that since they worked 10 hours on Monday they can work 6 hours on Tuesday, are illegal because even though the employees are not working more than 40 hours for the purposes of overtime compensation under federal law, they are working more than 8 hours for purposes of California overtime law, and rounding the 6 and 10-hour work days to 2 8-hour work days would cheat the employee out of 2 hours of overtime pay. Perhaps the biggest difference between California and federal overtime law relates to the administrative exemptions, primarily engaged in duties that meet the test for the exemption requirement, such as duties that involve exercising independent discretion and judgment as set forth in the controversial Order No. 4, whereas under the Fair Labor Standards Act, primarily engaged does not necessarily mean at least half. Under California wage and hour laws, less than half of exempt duties automatically eliminates the overtime exemption.